Hello and welcome. I'm Amritanshu Rai and you're watching Law of the Land on Raj Sabha TV. Today we bring to you the Benami Transactions Prohibition Amendment Bill 2015. To discuss the issue, I have with me Mr. Ajay V. Singh, advocate, and Mr. K.C. Mittal, advocate. Now for the headlines. The Benami Transactions Prohibition Amendment Bill 2015 prevents all persons from entering into Benami transactions. Any property held in Benami will be seized by the central government. The bill has exempted corporate firms, companies and associations from the ambit of the bill. The Benami Transactions Prohibition Amendment Bill 2015 prevents all persons from entering into Benami transactions. Any property held in Benami will be seized by the central government, and those found guilty will be punished with fine up to 25% of the market value of property.
The Benami law was approved by the Parliament in 1988 but could not be implemented as it did not have certain enabling provisions, because of which rules and guidelines could not be framed. Now the government plans to include the empowering sections so that implementation becomes possible. The Benami Transactions Prohibitions Amendment Bill seeks to prohibit holding a property as Benami and restrict the right to recover or transfer property held in Benami. The government proposes to provide a mechanism and procedure for confiscation of property held as Benami.
How you are going to confiscate the property, what are the mechanisms which will be involved, and how to check the power that has been given to the officer that can be misused also. So on that provision, the bill is not very, I can say it's silent on that part.
The Benami Transactions Prohibitions Amendment Bill defines Benami transaction as an arrangement where a property is transferred to or held by a person and the money is paid by another person, where the property is held for the direct or indirect benefit of the person providing the money. Any transaction made against a property where the owner of the property denies the knowledge of such property or makes a transaction in a fictitious name is also considered as Benami. All the properties involved in Benami transactions will be considered as Benami properties. No person being a Benamidar is allowed to retransfer the Benami property held by him to the beneficial owner or any other person acting on his behalf. The bill makes all such retransfers as null and void. Those who found guilty of the offences of Benami transactions with rigorous imprisonment up to 7 years and fine which may extend up to 25% of the market value of the property.
Crime. For example, in Prevention of Money Laundering Act, you are attaching the property which is a proceed of crime. When we talk of proceed of crime, we talk of such property which has been derived or obtained as a result of the criminal offence. In Benami transactions, this legislation now, it appears that the initiator who will initiate this, who is considered to be an initiating officer, he may on his own information give and say that there is some property which appears to be Benami and put that person to notice. Now how there may be problem in implementation, it may lead to excesses or arbitrariness, that time will show, but ordinarily I feel that there is a lot of overlapping and there may not be any certainty of the action that may be taken under this act.
The existing Benami law of 1988 does not contain any provision to keep the confiscated property with the central government. The law also lacked empowering authorities with powers of civil code for effective implementation. The Act does not have provisions for an appellate mechanism against an action taken by the authority. The bill seeks to strengthen the law through amendments. Narendra Modi government wants to contain and curtail the domestic black money which is available in wide circulation in the country. Government is also trying to generate and collect the land pool which is registered in Benami names. With camera person Shivakumar, Rajkamal Rao, Rajya Sabha TV.
The bill seeks to do three things: amend the definition of Benami transactions, establish adjudicating authorities, and an appellate tribunal to deal with Benami transactions, and specify the penalty for entering into Benami transactions. First of all, my question to you, sir, is do you see the bill being implemented whenever it is approved in prospective or retrospective manner? Because the dates, if you go see the bill, 1988 has been included, which was the first time it was passed. So the purpose of including that, could it be that they want to implement it retrospectively?
See, if we look at
Is there a possibility?
I'm coming to that. Whether a retrospective effect is required or not, I'm coming to that. If a property is being identified as a Benami property today, the question is the offense is a continuing one. So you don't need a provision for making it a retrospective offense, because offense is a continuing one. Now, a property which was acquired before and it was a Benami and then it was resold, it is not covered within this act. So I don't look at the retrospective effect at all. Whatever the initiating officer will do is he will identify a property today that it looks like a Benami property. So for that effect, the initiating officer has to simply say that you show whether this property is owned by you or not, or who's owning it.
I get the point. But on the, so what is your take? Do you get a feeling that it is going to be prospective and not retrospective? Or is the government somewhere or the other trying to retain or empower itself that whenever it wants, it can impose certain sections in retrospective effect? Is it possible?
You see, what you are saying is 100% correct, because if you read the bill itself, the very beginning itself says it's within the competence of the central government to notify the date when it becomes effective. Therefore, the government is free to do and give a date, effective date, when this act will bring in force if it becomes an act. But there is another aspect to the matter. That is, normally the law is that retrospective effect is, if you want to give it, then there has to be a specific provision in the act. That they have not. But here there seems to be a calculated attempt to merge it with 1988 Act itself. So it doesn't segregate. So it would be open to the government to go into and investigate all the properties which from 88 till today have become Benami or not become Benamis. All those transactions can be gone into.
That's a possibility.
That's a possibility, and retrospectivity to that extent will be within the competence of the investigating officer.
And the empowering provisions are
Correct,
there.
correct.
Sir, coming back to you, because this is an amendment. This is not a new law. This is an amendment to the 1988. And portions of 1988 are still approved and lying there, although not implemented. That's another point. But this is an amendment to that law. So the point that sir is making, which means the empowerment is there to treat it retrospectively. Are we correct on that
In
or
which
not?
areas? I'm saying implementation.
On identifying Benami. Benami, when does it come into effect? After the amendment is passed and an act is declared, or it comes from 1988? What?
Now, if you look at the bill is only creating an implementing mechanism for the act. As far as the act itself is concerned, it exists since 1988. Now, offences which have been committed after 1988, or even on the date when the act was passed in 1988, there existed a Benami property.
Correct. So, which means
Try
it
to understand.
brings into the ambit all such activities which have been Benami from 1988 onwards, correct?
You must mark it like this. These kind of offences are continuing ones. So if we have to challenge the bill or the act on the basis of saying that it's a retrospective effect, you have to show that the offence was not a continuing one, or that The property was acquired and was resold.
I get it.
Without specifying the retrospectivity, you are taking that power. That's the mischief, the calculated hidden line which one can read if you read between the lines. Then that is the whole idea, and that is how it is going to be implemented.
So, moving on to the next, rules and guidelines are going to be very crucial in this. And the way the government has empowered the entire mechanism that is going to be set up gives out clear-cut indications that it's going to be one effective way to curtail black money. But if you implement it in the rural areas, what do you see the impact? How do you see the impact?
See,
it is for black money.
See, if I look at the socio-economic conditions of this country, certainly this act is going to, the implementation of the act is going to create reverberations all around. And we are not oblivious of the fact that black money transactions this Benami transactions do take place in rural areas. But now look at the people who are doing it. They have exempted the families.
Correct. Correct.
So a large section of the people is already out. Now, who are the people who, even in rural areas, who are going to be impacted? Even in those rural areas, those people are moneyed people.
Yeah. Yes.
They are moneyed people. For them, whether they have 100 houses or 200 houses or whether they have got 1,000 acres in Benami, there's no limit. They are very big people, even in rural areas. So I don't see very poor people getting impacted by that unless, some kind of, there can be very rare cases, very, very rare cases. I would say that the law of the whole structure of recording of the ownership of properties is so misplaced that technically some people may be roughed by the wrong side. And for that purpose, I think the Act can make some amendments.
How do you see the exemptions? The fiduciary capacity is exempted. The HUF is exempted. The definition of corporates has been added. And in a way, how the corporates keep property in fiduciary capacity is known to everyone. And besides that, the families and their sons and the daughters, all of them are anyway exempted. So where do you see this law actually going?
Frankly speaking, if you ask me, as I read it, it will not take out the black money, but it is a way to legalize black money. What you are doing, you are nullifying 1988 Act, because Benami transactions were totally prohibited under 1988 Act, and except for wife or unmarried daughter for their benefit. So that was and even for co-partners, there was some escape route which was left where it was for their benefit. But today what you are doing, you are permitting corporates, you are permitting firms, you are permitting partners, you are permitting all kinds of relations, sons, daughters.
So what you are actually saying is that this bill is basically catering to the section which has been exempted and is actually empowering them to hold properties in a legal manner.
Correct. So you are legalizing the holders of Benami properties in their name, and you are giving them this benefit. It doesn't expose the black money. You are giving them this, that you hold on. There is no crime. What is the exemption? You see, what is the category of exemptions within the definition? It takes away, it's a sweep of exemptions is such where there would be hardly any Benami property which will be left.
Time for us to head into a break. When we come back, we will talk about exemptions granted to corporates. Welcome back. Properties purchased by corporate firms in fiduciary capacity may not be considered as Benami. The bill has exempted corporate firms, companies and associations from the ambit of the bill. It has also proposed to exempt members of Hindu undivided families.
The Benami Transactions Preventions Bill exempts properties held in fiduciary capacity from the purview of Benami transactions. Properties held by a member of an undivided Hindu family are also exempted from the purview of the bill. It also exempted properties acquired out of known resources of income by an individual in the name of spouse or child.
Proposed section 2 subclass 9, the company has been exempted, director of the company has been exempted. That means the law which is now being made will have no application on such issues which are relating to the company, or where the company is holding any property in a fiduciary capacity. This law will not apply to them. This is what it appears to be on the face of it.
The Benami Transactions Prohibitions Amendment Bill 2015 exempts persons or karta of members of Hindu undivided family if the property in question is held by him for the future benefit of the family, where the consideration of property is provided from known financial resources of family. It also exempts persons standing in fiduciary capacity for an individual, a company, a firm, and a body of individuals from the ambit of the bill.
I mean, going further, I'll try to link with the corporate social responsibility scheme, CSR. A lot of money is involved. There may be a chance, there may be a possibility that some corporates will create a foundation or trust, or what you have been talking about, the employing purchasing the land or the asset on the part of the company, but there is an understanding. But that is very hard to detect also.
The Benami Transactions Prohibitions Amendment Bill 2015 lays down the processes for penal consequences in the case of a prohibited Benami transaction. According to the proposed law, proceedings for an alleged Benami transactions will be initiated by an initiating officer with the rank of an assistant commissioner or a deputy commissioner defined under the Income Tax Act. The initiating officer will refer the case to the adjudicating authority set up under the proposed bill. The relevant adjudicating authority will pass an order within a specified time after hearing the alleged Benamidar, the beneficial owner, or any other interested party, including a banking company and another person who makes a claim in respect of the property. The bill proposes to give powers of a civil court to the adjudicating authority established under the bill.
Where there is a citizen is put to strict, loss, or there is lot damage to the citizen in terms of property and all that, the criminal law operates very strictly. You have to construe it very strictly. So 99.99 record, always such legislations operate prospectively, never ever come retrospectively. So this will have prospective operation. It will not have retrospective operation.
The bill proposes to set up an appellate tribunal to provide appeal against the order of adjudicating authority. After the order of adjudicating authority becomes final, central government will confiscate the properties held as Benami. Confiscated properties are to be managed and disposed of by officers designated by central government. The bill empowers the central government to make rules for the implementation of the provisions of the bill. It has made provisions for central government to designate one or more special courts for the purpose of the bill in consultation with High Court's Chief Justice. When Benami Transactions Prohibitions Amendment Bill was introduced by UPA government, the Standing Committee on Finance headed by Yashwant Sinha objected the provisions and the exemptions provided in the bill. Even this time, the BJP government is facing the same challenge from the Congress quarters. With camera person Shivakumar, Raj Kamal Rao, Rajya Sabha TV.
Under the existing law, an authority to acquire Benami property was to be established by the rules, but the rules were never made. Now the bill seeks to establish 4 authorities to conduct inquiries or investigations regarding Benami transactions: the initiating officer, approving authority, administrator, and adjudicating authority. Now the way it has been structured, I'm coming to you, sir, the initiating officer and the power and the loopholes that have been provided in the entire Benami bill, which is supposedly meant to tackle the menace of black money in this country. How do you see the role of the initiating officer? Does the government or does the system depend too much on the initiating officer to do too much?
See, as far as the initiating officer is concerned, he has to proceed according to the act if it is made. But look at, before that, the initiating officer will first go to one issue, which are the Benami transactions, which properties. If you look at the exemptions, which I was pointing out to you earlier, basically what it seems is that this bill is meant for big business houses or the corporates. And it permits, as a matter of fact, if I am permitted to point out, the HUF, then the definition of companies, the directors, partners, and is so wide which has been defined. Then it includes even the sons, and which was never before. Then it includes even the lineal descendants, ascendants, the cousin, brother,
very
sisters,
very broad,
and then look at it. Another important aspect: transactions are an arrangement in respect of the property carried out or made in fictitious name. What is it? What are you? I mean, I don't know what remains. And then so many things. See, if you look at that,
whom is the initiating officer going to catch?
correct. That's the point. The initiating officer can hardly do anything. More than the initiating officer, we have first to see what is the whole idea and purpose of this act. This act is totally beneficial for the persons, those who are holding properties in different names, and the Benami holders, where what was the whole idea? You see, where it started. In 1976, initially, when there was an amendment in the income tax, what was said was that there was tax evasion. The revenue was not coming because of these, and it was being abused because of the Benami transaction. To put a check on that, the Income Tax Act was amended in 1976. Then there was a subsequent amendment in the Trust Act. All that failed. Then the Law Commission report comes. Then comes...
So nearly 38 years.
Yes,
we still have a very weak Benami. Initiating officer, sir. Your take on the role of the initiating officer and how the mechanism has been structured.
See, initiating officer in any act is basically an investigator. Now, an investigator, as far as investigation is being done, is fine. But giving power of holding the property for 90 days without any hearing or any opportunity to the person concerned or getting affected is too much. How can you trust an initiating officer to that extent that he can hold the property? It's like passing a verdict without hearing anybody.
And where does he get the information from? I mean, where do you think an initiating officer will get?
These are grey areas. And what happens in the grey areas is very obvious.
So he finds his own way and makes his own decision, and he has been given a free hand.
I would say that the intention of the act is very different, but this area is weak. The intention of the act is to track down black money. But if you have, too much of trust in this structure on an investigating officer or initiating officer, I think that would lead to very absurd results.
And so the fiduciary capacity, very quickly, sir, we've got very little time. Fiduciary capacity, how do you see? The way the property is held in fiduciary capacity these days, that is exempted. Can you just...
There are two things. My friend says it will track the black money. With great respect, it would not. It's the other way. It's going to be the other way. That's not correct. The perception is wrong that it will be a check on the black money. It is legalizing black money as a matter of fact.
Correct.
By a statute, you are doing it. As far as fiduciary capacity is concerned, that again, what they have done here under the exemptions is so wide, so wide. Earlier, there was only a limited trust. Fiduciary is basically some property held in trust for the benefit of the trustee. That was the limited, the exception which was available. Now you have even added the limited liability partnership here. Even those partners are exempted. That would mean a foreigner can come and be a partner here and get an exemption on this property and hold property.
Is that so, sir? Do you see that happening?
The definition
is the possibility.
See,
no, there is a definition.
Quickly,
I look at this like this. In fiduciary capacity means that the money comes from the known channels. The person is a known person. He is not a Benami. The money which has been, the money by which the property has been bought is a tax-paid money.
But will he be forced to disclose this under this act to the PML system?
If it is not from the known sources of the company, then it's not covered in this exemption. Automatically goes out. Then it is not in fiduciary capacity. Fiduciary capacity means that the company has purchased a property from its known sources, from tax-paid money in the name of somebody who's working in the company as a director. Try to understand. It is not a Benami property as such. I look at it this way.
So that's a legal
Where does
point.
it say so? Where does it say so?
Moving on, sir. Moving on, my colleague Raj Kamal Rao spoke to Mr. Virendra Ganda, senior advocate, and tried to get his point of view.
By and large, the experience with the tribunals, the central government experience with the tribunals has been 50-50. Some of the tribunals have done very well, and some of the tribunals have been totally failure. Say, for example, BFR, AFR. See, in the beginning, they did a very good job. First few years of SICA coming into force, they did a very good job. But then eventually it got so much tapered down, and now it becomes more of a nuisance than a real tribunal.
Thank you, sir, for joining us on this discussion. It's time for us to end the show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our shows on the RSTV page of YouTube. We'll be back with a new issue and a new episode. Keep watching Raj Sabha TV.